What you need to do is improve on this 300. That's what the law should come in. My mother was a grade 1 teacher. These people who stopped in junior something. She's now earning, she's 96 years. She's now earning 190,000 shillings. What is this which I'm not understanding? Which kind of government is this one? Which leaves people at 3,000 from 1992. And every year there's been an enhancement. What we need to do to help these people is, let's change this money, factor this in the law, and bring them to the level. They have missed several increments. So put them on an increment and they come to the level. That's it. Than looking for this regulation here and there, it can't help. Because already in their record, they're on pension. In their record, they're on pension. So if they're on pension, propose something here that will lift this 3,000 to be useful to them. That is it. And that will solve these people's problems. There's nothing here which I've read which can help them. Nothing. Not even. And don't put them in regulation.
The general aspect of the bill, improving the welfare of the combatants and former combatants. That's point number one. Because as you see, these people have been under public service.
Yeah, just on clarity. Not those who left. That's where the concern is. Improving those who are going to live in now, not these ones. So we need to do something to these ones who are also there.
Actually, they are veterans who are under Bank Front and those other NALU, UNLA, they are not addressed. So that's it gives us an opportunity to address, as we address them.
We are in concurrence that the situation has been very bad for you. I'm going to give you a chance. Yes, Honorable Abdallah.
Chair, my simple and brief submission on this. I don't have kind words for my fathers here, because true, they might have saved us from dictators, but if they are to assess where we came from and where we are, I hear these days calling the current regime also full of dictators. So I don't know whether they are proud of where they came and where we came from and where we are. And the only way, please prevail. I'm here. My submission is the only way to prevent further problems for this country is to not even consider these people's submission here. Otherwise, other people will come and join the struggle, pretending that they are fighting the dictators and create more problems. Thank you.
And rightly so, because they really did a good job for the country. The rest is not theirs, it's for you, the politician. The rest is for you, for them they did their work. And that's what they are saying. They did their work and they are proud about it.
Honorable, have come here because they are on record. They are known people in the system of government earning 3,000 shillings. That's why they are struggling to come here. They are not just a batch of people outside, just there. This is what makes them to come here.
So let's finally have Honorable Katuntu on this matter and we close it. Or maybe let him first speak and then.
Thank you, Honorable Chair. when we are out there, we all how the MPs debate. Some of us maybe request my honorable, who is near Honorable Fox. He was comparing us with Karamajongs. Really, for us, even someone was saying that comparing our regime with those dictators, something like that. I wanted to request them that you understand us and our request. For us, we took our arms and we fought and we won. If they also win, they will also ask for the same privileges.
I like that. End it at that. That's enough. Actually, I wanted to say it, but you have said it. When they finally win, they will also be proud of their struggle. Let us have Honorable Katuntu and
among others is to provide for the welfare and pension of the serving officers and also those who have served in the past. Unless we have a retrospective effect or clause. Legally, is it possible? Yes, it is possible. James, it is possible to have a retrospective clause that can cater for categories like his. I am not so sure that I'll address my mind to what my colleague there is talking about of the rustlers. Then they are going to get free animals. So then we are legislating to provide pension for such categories. Really, I'm not going to be in company of that. I'm not going to be. But people who were really employed by this government, they took over and they continue serving as the NRA or UP. Actually, this was NRA, I guess. NRA officers. To imagine that they are getting 3,000 shillings. Do they take that 3,000? Is it put on your account? So even, oh, you pick it in the cash. If it goes to an account, it will be wiped out by banker charges. If they say pick it, the transfer to pick it is more than. So it doesn't make a legal, neither does it make a common sense. And our colleagues from the UPDF who are with us in Parliament, this is a very, very serious matter, James and General Edward. You need to go back in-house and urgently address this problem. We don't want to hear these sort of stories, really. It's painful. It's really painful. So, can we agree, Chair? First of all, this should have been an internal discussion on how we are going to handle it. We've listened to their plight, and I think we all agree in principle, save for my brother Abdallah, that this category should be catered for in this law. Leaving it to regulations, I think there is a problem there. Because regulations are supposed to be implementing the principles in the parent law. So unless you have a provision specified looking at a retrospective effect, the regulations cannot cater for this. So at the time of writing a report, we need to move specific amendment, which we can do legally, which can cater for this kind of veterans. Otherwise, we all sympathize with the situation. And I think we commit ourselves to handle it, Mr. Chairman, today.
Thank you. That brings us to the end of our interaction with you. Thank you. If you keep in touch with the clerk, they will tell you how we have handled it. Thank you so much. Interaction. You are discharged. Mutuke bulungi jamulaga mwebale nyo mwebale. Abdallah werekera abagenyi baffe. Abdallah, this is chairman's order. Yes.
Retired Sergeant Wile Tulinawe Wile. the chairman for Kampala Region Veterans League. I'm here with my colleagues, Commander Tabora, Chairman Rubaga, Madam Alice from Nakawa, Chairman Nakawa, Lieutenant Mugume, Kenneth and Ochan from sub-counties of Nakawa. We are here to, first of all, we want to appreciate the Parliament for considering us by receiving our views to be put in the UPDF amendment bill. Some people from the general public, they think the UPDF bill is all about the general court martial only, but it has a lot of things within the UPDF. Our main concern was the pensions for the retired officers and men who retired from 1992 to 1995. However, other areas of retirements, they are covered somehow. And we are glad that the Parliament of Uganda has promised us to work on our issues. I thank you.
We've got information that since
92 to 95.
what?
Per month. On that issue, of course, we retired at different works. But I can assure you with confidence that there are some who are getting that 3,000 in a month. Even they got surprised. But it's good that there was proof, and we are happy that they are going to work on it. Of course, the challenges, you know, everything rotates on money, on income. If you are getting a pension of 3,000, what do you expect? It is you to suffer school fees problem, even feeding alone. That's why even some of us, we appreciate because of being here. Our colleagues, many of them died because of low payments of that pension. So those are some of the results of getting that small money. Amanya nze tulina wire nkolanga chairman wa region owa Kampala district natambudde ne banange nyinawo Commander Tabora ndowooza naye ajja kwogerayo ekigambo nga yakulira Rubaga, Alice Mugabe kazi nga yatukwatira ensawo mu Nakawa, ne chairman wange owa Nakawa Lieutenant Mugume, then ne Sergeant Ochan ne Kenneth abava mu divisions nazo eze Nakawa. Tuze wano mu Parliament okuwaayo ebirowoozo byaffe okulaba nti bikwatibwako mu mateeka agagenda kukyusibwa ga UPDF bill. Tuli basanyufu okulaba nti UPDF ya Parliament yatwaniriza bulungi era ne tuwaayo ensonga yaffe okusinga ensonga zaffe zibadde ku pensioni. Mulimu ebintu birala ebya court martial, ebya welfare y'abasirikale, ebimu tubeebaza, ebimu biriko bulungi, biriko somehow. Naye ku nsonga ey'omusaala, most especially ogw'abasirikale abaawummula 92 mpaka ku 95 kibadde bubi. Omwezi si ffena naye nga abasinga abasembayo bafuna 3,000 omwezi. So n'olwekyo tusabye ne batusuubiza nti bagenda kukikyusa kibeere nga banaffe kuba banaffe abawummula kati osanga oli afuna emitwalo 3 nga gw'ofuna 3,000. Mukiraba namwe si kyabwenkana nti ffe twali tukola omusaala gwali mutono kuba n'okusinga twali tuyamba eggwanga, twali tulwanirira eggwanga lyaffe. So okulaba omuntu afuna emitwalo 3 gw'ofuna 3,000 kiba si kyabwenkanya. ku lw'obwavu era naffe kyatuyamba kujja wano wa Kabaka wano n'atuyiyiza naye era singa tuli mu kyalo luusi singa tetukyaliwo so n'olwekyo twebaza ne Kabaka okutulabirira bulungi tuli wa Kabaka. What I'm saying that because of low pay, of course, you cannot survive on 3,000. But some of us, we are here because at least within Kampala here, we got support from, we have where we are. Like when you go to Kafumbe Mukasa, that place is for the veterans. When you go to Port Bell, it is for the veterans. So we appreciate the Kabaka of Uganda for having catered for us as veterans and the government of Uganda, because without them we wouldn't survive.
Amanya mpitibwa Haji Tabola Moses Mayinja, veteran, chairman wa veteran atwala Lubaga district mu NRM. So olwairo tuli basanyufu nnyo naye parliament okulaba nti naffe batuyise okuwa ebirowoozo byaffe ku nsonga z'abaveterans abawumula 92 mpaka 95. Tubadde abantu abamu bafuna pensoni kwegamba eyeralikiza n'okwogera omuntu 13,000 ate banka nezitwala kati abantu ne babeera mu bikolimo buli kaseera naye olwaleero olunaku lulungi okulaba nti tuli basanyufu ebirowoozo byaffe akakiiko kabyaniriza era ne batusuubiza bagenda kukikyusa tulabe nti naffe tutunkana n'embeera eriwo mu ggwanga. Nolwekyo mu mbeera embi gye tubali twogerako tujja kwebaza nti Oweekitiibwa Pulezidenti nga tukwanaganya wamu ne Kabaka wa Buganda baatufunira ebifo naddala ng'abali mu Kampala we tubeera ogeza nga Kafumbe Mukasa Luzira wa akati Obwakabaka bwatwaniriza ate Oweekitiibwa Pulezidenti n'ateekayo amaanyi naye embeera ebadde ereese obuzibu yeya pensoni eno yokka naye baatuwadde omukisa tujje tulabe nga tutereeza ensonga eyo. N'olwekyo Paalamenti tujja kubeebaza batuwadde essuubi nti ekyo bagenda kukikyusa okulaba ng'omuntu afuna pensoni esaanidde. Bannaffe abamu baafa nga ono bwagambye lwa mbeera mbi naye ffe abakyaliwo Katonda atuyambye katusabe ti Paalamenti yaffe egenda kutuyamba ekintu ekyo kikyusibwe neyanziza nnyo.
And then the criminal trial proceeds. Non-derogable rights are provided for under Article 44 of the Constitution. The right to a fair trial is non-derogable. Every accused person, whether they are charged in the civilian courts or previously in the military system, they are entitled to a fair trial. Therefore, if an accused person complains that I think I'm not getting a fair trial, it is important that that question is determined before any other steps are taken in a criminal trial. And therefore, the provisions of the Human Rights Enforcement Act are intended to apply to the entire criminal justice system and not merely the civilian system. Mr. Chair, the two members who have entered, Ms. Patience Babiwemba and Mr. Blaise Rugamba are part of my team. They are all advocates with whom we have done work in this area. So our proposal is that this bill should incorporate applicability of the Human Rights Enforcement Act, Chapter 12, Laws of Uganda. These provisions will make it easy, no matter what happens at the end of the day, no matter what this committee decides, no matter whether this law is passed or not. Once it is passed, if we are to have military trials, whether of members of the defense forces or civilians, surely we cannot have a situation where we have a court which is outside the jurisdiction of the Human Rights Enforcement Act, Cap 12. the problem we have in practice now is that some individuals who were previously charged in the court martial could not file applications under the Human Rights Enforcement Act to the court martial because the act specifically provides that you can only complain to the High Court or to a magistrate's court. When applications would be filed by accused persons in the court martial to the High Court, the High Court would consistently dismiss those applications and claim that these matters should be addressed by the court martial, or accused persons would be advised to file petitions or to the Constitutional Court. And therefore, people who had complaints of rights violations, especially arising out of custody and similar situations, were left with no remedy. If we had had time, I would have brought over 10 rulings from the High Court about this area. Maybe someone is detained and held incommunicado. I have one such case for 4 months. And then later is arraigned before the General Court Martial. And he has nowhere to even complain. The General Court Martial says, for us, our mandate is to try you. These other things of your rights were violated. Maybe you go to the other civilian courts. For us, our mandate is to try you. And therefore, it's our request and proposal that this area should be resolved. If the military court, if the General Court Martial, the Division Court Martial, the Unit Court Martial, if they are going to have to be seized with a criminal trial of any kind, they must also be given the obligation to apply provisions of the Human Rights Enforcement Act. Once that is done, it probably could also array some of the fears and concerns that many members of the public continue to have about the quality of trials in the military system. The second point, Mr. Chair, the bill does not cross-reference or incorporate provisions of the Explosives Act, Cap 319, Firearms Act, Cap 320, and the Toxic Chemicals Prohibition and Control Act, Cap 329. There is a clear conflict between provisions of the bill on what constitutes classified stores that are ordinary monopoly of the Uganda People's Defense Forces. I will explain briefly. We have the Firearms Act permits people who are not members of the defense forces to get licenses and have firearms of a certain category. Not SMGs, not grenades, but for example, pistols. But now the schedule to the bill says pistols are ordinary monopoly of the defense forces. Mr. Chair, I submit that this could be a cause for problems. Innocent Ugandans who are licensed to carry firearms and who have firearms could find themselves being treated as subject to military law when clearly they have done nothing unlawful per se. I could have a firearm, I don't have one. I could have a firearm and I'm licensed to have one. And then I delay to renew my license. At that point, I have committed an offense under the Firearms Act. But also, I'm perilously close to this amendment, the definition of, because I'm now holding a pistol and this bill is saying that is also ordinary monopoly of the defense forces. I believe it's an error that's arising out of the omission to give consideration to the provisions of the Firearms Act on the categories of arms which civilians are allowed to hold. The same applies to the Explosives Act. We have people in construction who are doing rock blasting in mines, people in road construction. Who licenses these people with their explosives? Is it the army? And what happens? So, if we say explosives are ordinary monopoly of the defense forces, which is correct, shouldn't we specifically make provisions for civilian use of these to avoid confusion and also to avoid a possible misuse or abuse of these provisions in the future? Because as far as I'm concerned, people in mining, people who do rock blasting for road construction use explosives. And I have not seen the defense forces doing that on their behalf. So this committee needs to decide. The members of the defense forces can also guide. When I want to do rock blasting, will I request the army to do it on my behalf? Yes, the generals will probably guide us. But I propose there is a clear need for this committee to guide and ensure that there is proper reference to these laws to avoid a contradiction in the statutes. The same for the Toxic Chemicals Prohibition and Control Act. It's the same issue. There are chemicals which people have. I'm wondering whether our chemistry teachers are safe when they are carrying chemicals from Kampala and they are taking to their laboratories up country in Abim, in Kabale, in Chisoro, and then they are intercepted by security, and someone is carrying chemicals. Tomorrow, if they are taken to the military court, what will their defense be? So again, an area that requires very careful thought. Therefore, I request that the schedule, it's our proposal that the schedules on what constitutes chemicals, explosives, or arms that are ordinary monopoly of the defense forces.
Can I give some readings?
Yes, Mr. Chair.
I propose, Council, that you read your statement verbatim, such that where we... Yeah, but even the other side is even better. When he reads it. Then we will seek clarification and then he will explain further.
Yes, I'm on page 3 of the presentation.
Communication from the speaker to wind up and report in line with what we agreed. I communicated and she says we should wind up and go to the house. So.
Okay, thank you, Chair, for the guidance. So we'll move to point number 4. The High Court. The High Court is generally clothed with supervisory jurisdiction in respect of all matters of law and procedure over subordinate courts. We propose that the High Court should have supervisory jurisdiction by way of revision over proceedings in the unit and division court martials. Supervisory jurisdiction. A right of appeal to the Court of Appeal from the General Court Martial is insufficient in protecting integrity of proceedings in these two lower court martials. Revision powers of the High Court should be incorporated in the UPDF Amendment Bill in reference to proceedings before the Unit Court Martial and the Division Court Martial, because as the bill is as drafted, the bill makes those two categories of court martials subordinate, and yet they have quite very stringent powers. The next point, paragraph 5 of the memo, the Supreme Court should have the usual jurisdiction to entertain a third appeal subject to the law on third appeals in respect of trials presided over by the Unit Court Martial and the Division Court Martial. Mr. Chair, the bill as presented provides for a right of appeal from the Unit Court Martial or Division Court Martial to the General Court Martial, and then only one right of appeal to the Court of Appeal to close the matter. That is insufficient given the nature of offenses that are proposed to be covered. A person charged with murder in the civilian system gets two appeals. A person charged with murder in the military system is only going to have one appeal. That's not fair. There is very limited difference in jurisdiction between the Division Court Martial and the General Court Martial. Appeals from the Division Court Martial should equally proceed directly to the Court of Appeal on a first appeal, and Supreme Court on a second appeal. The only difference in the bill between the Division Court Martial and the General Court Martial is that the Division Court Martial cannot impose a death sentence, but they can impose any other sentence. Therefore, technically, the Division Court Martial and General Court Martial really have the same powers in all respects except on the death sentence. Similarly, all matters heard by the General Court Martial in exercise of original jurisdiction should be appealable to the Court of Appeal and Supreme Court, like for all ordinary criminal trials that commence in the High Court. Clause 195 should be modified accordingly. There is only one right of appeal provided, from the General Court Martial to the Ordinary Court of Appeal. That's insufficient for sure. Number 8, I'm on page 5 of the memo. The tenure of members of the Unit Court Martial, Division and General Court Martial should be restricted to one non-renewable term of 7 years. In its present form, the bill's provisions on the tenure of members of the court martial do not guarantee security of tenure, which is a constitutional requirement. Under Article 28, Clause 1 of the Constitution, for any judicial officer in order to have an impartial tribunal. See the Constitutional Court ruling in Businje Kabumba and Andrew Karamaji versus Attorney General, Constitutional Petition number 15 of 2022, which considered the practice of appointing acting judges was outlawed as offending security of tenure. Security of tenure goes to the heart of the fairness of a court and its impartiality. The bill gives contracts of 3 years which are renewable. What happens to those trials which members of the court martial handle a few days, a few weeks before that contract expires? And the standard internationally is that is not security of tenure. A 3-year contract which may or may not be renewed does not guarantee security of tenure. So either give one term of 7 years, that's our suggestion, or follow the path of the judiciary. I recognize the challenges in the path of the judiciary because members of the court martial cannot have tenure till retirement. It will look a bit funny. That's why our proposal was maybe 1 year non-renewable term of 7 years. The appointments of members of the court martial are still a preserve of the High Command. The proviso for consultation with the Judicial Service Commission is vague and ambiguous. It should be a legal requirement that the Judicial Service Commission will examine and vet the intended appointees with regard to their competence in matters of the law and adjudication, as well as overall suitability for a judicial role. Clause 195, Clause 2, should be adjusted to provide for the Judicial Service Commission to vet and examine nominees for appointment forwarded by the High Command. Let the High Command forward its individuals, since they are lawyers, but determining their suitability to play a judicial role, let the Judicial Service Commission at least have that no objection, since it has competence to determine who becomes a judicial officer. The current clause simply says they will appoint in consultation with the Judicial Service Commission. The consultation is not defined. It's not clear what they would do in the entire process. I recommend, Chair, that this clause should be adjusted in these terms. I'm on page 6 of the memo. The qualifications of the chairperson of a division court martial. The qualifications of the chairperson of a division court martial should also be equivalent to those of a high court judge, since this court can impose any sentence except the death sentence. Mr. Chair, it is now unusual in the civilian system for death sentences to be imposed. In 95% of the criminal trials, whether for murder, aggravated robbery, terrorism, and all, generally the practice is to impose lengthy prison terms, which a chairperson of the division court martial has powers to impose. With the division court martial has powers to impose those sentences. But the bill simply says the chairperson of a division court martial should have a law degree and then a diploma in legal practice. That's inadequate. This is a very powerful position, Mr. Chair. Similarly, other members of the division court martial, just like for the general court martial, should have legal qualifications, since in reality there is little difference in the sentencing powers of the division court martial and the general court martial. Then next point, number 12, the jurisdiction of the general court martial, the jurisdiction of the general court martial should be restricted to offences under the UPDF Act, as the court martial should not be set up as a rival court to the ordinary courts of judicature under the Constitution, which preside over trials for offences under other criminal statutes, especially the Penal Code. It's our case that the General Court Martial, as the Supreme Court ruled, should exercise specialized jurisdiction. In other words, it should try those matters which the civilian courts may not adequately handle because they involve some technical knowledge of the military system. That is the principle. Just like we have a tax appeals tribunal whose members are judicial officers still in a sense, but they have a little more competence in tax matters. Similarly, that should be the spirit in which the court martial should be set up to operate. Let it have jurisdiction for offences under the UPDF Act. But when it starts going to the offences under the Penal Code, Firearms Act, Terrorism Act, it becomes a problem. And the current wording gives it jurisdiction all over the place. We request this should be restricted to offences under the UPDF Act. Then we propose in paragraph 13 of the memo, it is the duty of the General Court Martial to forward a record to the Court of Appeal and eventually to the Supreme Court where a sentence of death is handed down. It is a constitutional requirement that a sentence of death must be confirmed by the Supreme Court. Therefore, clause 225, subclause 3, must be adjusted to comply with the Constitution. A sentence of death cannot be implemented before it is confirmed by the Supreme Court. And therefore, it should be the duty of the court which imposes it to forward its record to the Supreme Court for confirmation. That's an area we request for further clarification. Then clause 117A on persons subject to military law, in our humble view, clearly disregards and departs from the reasoning, decision, and directives of the Supreme Court in Michael Kabaziguruka versus Attorney General. Mr. Chair, the Supreme Court ruled in Attorney General versus Michael Kabaziguruka, Constitutional Appeal number 2 of 2021, that trials of civilians within the military courts should be only in very limited and exceptional cases. Very limited, exceptional cases. In utter disregard of this guidance and position, clause 117A instead proposes to widen the scope of coverage of civilians that may be subject to military law, instead of limiting and restricting the existing standard. The existing standard is the Supreme Court already found it too wide and asked that it should be further narrowed down. Instead, clause 117A is expanding it. I don't know whether the clause was drafted in a jest, but probably it's an error that should be corrected at the committee level. Exceptional circumstances, Mr. Chair, were defined at an international level by the Human Rights Committee of the United Nations in General Comment number 32 of 2007, paragraph 22, to mean that the state must demonstrate with regard to the specific class of individuals at issue that the regular courts are unable to undertake the trials, or that other alternative forms of special or high security civilian courts are inadequate, and recourse to the military courts is unavoidable. In other words, civilians should only be subject to the military system if it is clear that the ordinary courts are not adequate. Mr. Chair, this is the standard. Clause 117A clearly needs to be redrafted to provide for this standard. We have courts of judicature in all parts of the country. I read and respect the President's communication he made some time back about the Karamoja sub-region, but as we speak today, I know we have even a High Court judge sitting in Moroto. We have magistrates courts in Abim, in Nakapiripirit. If we ever have a situation where there is a part of the country where the judiciary is completely absent, then there could be a case to be made. That is what the international standard. Clause 117A is clearly in contempt of the Supreme Court decision and also flouts all international standards on the extent to which civilians can be subject to the military system. And therefore, lastly, it's our position, Mr. Chair, that clause 117A merely classifies certain offenses for the court martial. The standard for trying civilians has not been demonstrated at all. This is because it does not exist within Uganda, and there is no justification for clause 117A, given that ordinary civilian courts try far more serious offenses, such as terrorism and treason. This clause 117A, Mr. Chair, ought to be deleted so that we have a very nice bill looking after the welfare of members of the defense forces. It should not give this good bill a bad name. It's a good bill. I would give it 85% of this bill is very good. We have 3-4 clauses that are giving this bill a bad name, and they can end up becoming the legacy of this bill. Mr. Chair, I beg to submit. That's our position as a law firm. This opportunity.
Council Jude, thank you so much. This paper definitely will. Colleagues, you have heard. Honorable Kiwanuka.
Thank you, Chair. I have to appreciate my...
This bill has how many clauses? When the drafting was the problem? Okay.
Yes, there is a bill, there is a clause now, 117A.
76 clauses.
Under third, something like that.
Okay. So you have to...
Thank you, Chair. To inquire, because these are criminal matters which are taken under the court martial, whether you took the initiative to know how the cases should be handled before they reach court, especially when you take the line with the ordinary courts that before the criminal cases can reach court, there is always that investigation part done by police and then the sanctioning part done by the DPP. I don't know whether you took the initiative to know how best that one can be handled before the case can reach the court martial, most especially when to deal with those exceptional circumstances. Who has to determine which case is exceptional to appear before the court martial? Thank you.
I need to appreciate a counsel from Law Society, if I have not mistaken.
No, I'm not representing Law Society.
Yeah.
I came in my individual capacity just so we don't cause problems.
All right. I appreciate your submission. When it comes to clause 117, which you have recommended, that if military court, if the civilian court, the other usual courts are unable to handle cases which are being admired to be taken over by military court, you have recommended that you wouldn't support it, but to a minimal extent, you would recommend to support it. I'm of a view of inquiry from you. What if you had recommended for deletion than leaving a minimal gap for handling it? What is in your view? Then I need also guidance. We are having 3 organs of government: the legislature, executive, and the judiciary. Which organs are supposed to work independently? Why, in your own opinion, why would you support the 80% of in support of the court martial taking on cases, no exception of the civilians? Because in your own submission, you have only supported that the civilians only must be exceptional case. But if with the military you support it, 80% to give this bill a good name. Yes. We will answer. So what I needed to know, why should the executive that houses UPDF, police, to compound up with the state, why should they have any house within the judiciary? What would be, in your opinion, as a guidance to this committee? Would you support it? I don't know whether I'm clear.
The last bit I've not understood.
Let
Go
me
to the
come
first
again.
one, the second one.
If UPDF court martial is granted a house,
We had earlier accepted the Luganda in the committee, so you can use both.
maybe I would try Lusoga. If UPDF under court martial is granted a room in the judiciary to carry on the role, there would be work of the judiciary. What would be in your opinion? What is in your opinion? Would you support court martial to be housed under judiciary, yet it is an entity that lies in the executive? Maybe that one may come out clearly. Thank you.
Maybe let me try to, within the judiciary, for example, the High Court, like you have anti-corruption, like you have commercial, or a division within the High Court that can take care of cases which we are talking about. Are you talking of something like that? Because we need to understand you. I'm sure even the witness would want to understand what you are saying.
Position that the UPDF is under the executive. If we create a court martial, we shall be granting the executive an in-house judicial arm. And his question is, why should we do that?
Actually, you have made it more, and no. In your own opinion, Council, what would be your guidance to this committee? Should this committee recommend court martial, which is an entity under UPDF, which UPDF is under executive, to be housed within the judiciary? Thank you.
Honorable Tebandeke. Accused. I wanted really you to expound on this, because the chemicals and under Chemicals and Toxic Chemicals Prohibition Control Act, they are specific. Equally with the explosives, we have commercial explosives. I think this parliament did enact that law, and it gives exceptional. So in your wisdom, do you think that there should be a clause, or we should give an explanation on the explosives, and then even the type of the pistols, because even you talk of pistols. But then I wanted to pick your opinion. If I illegally got a pistol and then I misuse it, would I be a candidate for court martial, or I would be a candidate for this civilian court?
Thank you.
That is the area.
Thank you, Honorable.
That the court martial should restrict itself to trial of the offenses that are not provided for in the penal code. I'm aware of the provision of the penal code, I think section 2, which limits the jurisdiction of our courts because it does not grant extraterritorial jurisdiction save for cases of treason and misprision of treason. Now, I want you to advise on situations where you would have a military personnel who has committed murder in an operational area, like in Somalia, and we have to try him. What would happen if we just restricted ourselves to only the offenses provided for in the UPDF Act?
I want us to relate Article 139 of the Constitution, if I would read it, the High Court having unlimited jurisdiction over all matters. And I want also you to look at people who have been arrested in Uganda, like Jamiru Mukuru, for example, having led a certain rebellion group, and that person is not being taken to court-martial, and others who are civilians arrested on different offenses are taken in the court-martial. Don't you think that the High Court, with its well-qualified judges, can handle all matters except those which are so exceptional, but those exceptional cases should be given a section of how they become to be exceptional cases to be tried in the court-martial? I want you to take us through that line. Thank you very much.
Patrick.
Thank you so much, Mr. Chairman. Mr. Chairman, earlier on you had raised a red flag.
There is no problem. Yes, Honorable Patrick.
Actually, Mr. Chairman.
Yes, Chair, allow me, International Criminal Division. Can't it handle International Criminal Division? Don't you think, Council, that International Criminal Division can as well handle matters like General Mikira talked about, for example? Don't you think? Don't they have capacity to do that, in your wisdom? Can't you also take it?
My first concern was in regard to time management, because earlier on you had raised a red flag that probably would handle this very fast and join the others in the chamber. But Mr. Chairman, sir, if that is the case, because really this memorandum is very elaborate, I want to thank Councillor Jude, with whom I studied at the law school. Thank you so much. It will really enrich us as a committee. But something small with me, because honorable members, in summary and in my understanding, this bill is dealing with civilians to be tried in the general court martial upon commission of certain offenses. But there is somewhere where you said, where you talked about the monopoly. Just on page 3, where you talked about, of course, the monopoly of the defense forces in regard to the ammunitions. Now, honorable members and Mr. Chairman, in my understanding is that when a civilian is permitted by license to hold a firearm, once they commit any offense, they should be tried in the civilian court. That is my understanding. But when you hold it unlawfully, then you will be taken to the general court martial. Now, Councillor Jude somewhere is saying that there would be instances where a civilian who is holding it legally by license would be charged in the general court martial. If you can help me bring out those instances, if any. Thank you.
Can I have colleagues who came in later, not late, but later? Introduce yourselves quickly.